there were 2 deeds recorded.
And secondly, you talked about, and I'm not sure what the right legal terms were, but you talked about extenuating definitions of family members. Is there a family relationship between John Partridge and Clive King?
No.
Okay, so
No.
I'm not sure what that had to do with your argument of why it shouldn't be assessed.
Well, what it had to do was I said that when the board passed that resolution in November of 2006, that there was, as I read it, there is a statutory defect in the resolution itself, and if necessary, I mean, I would argue that that invalidates the whole resolution, but again, that wasn't
But you
really...
agree that even if it is an error, that does not apply to this case?
Yeah, that's right, and that's why I addressed that point.
Thank you.
How do you spell your name, sir?
C-U-R-R-A-N. I'll leave you a card.
A question for Mr. King. Did Mr. Kern represent you at this transaction?
Not at the time, no.
Not at the time. Did you have representation?
No, sir.
So you're relying on the title company to have the right paperwork for the transactions that were conducted?
We would think that under the rules of this Commonwealth of Virginia that the title company would follow those rules, which appeared not to be the case.
And one other question, was there a realtor present at the closing?
No.
There's no realtor present.
Mr. King, is it true that both of these transactions occurred on the same day?
They were both recorded on the same day, and they were in the local court, as well as the transactions took place on the same day.
Was this multiple transaction, this arrangement? No, let me take that back. Was this multiple transaction pre-arranged between you and Mr. Partridge?
Mr. Partridge brought this to my attention. I was not aware of anything on the other, let me put it this way, on the other side of the transaction that he was conducting, I was not aware of any part of that at all.
Now, it's something I think I'll clarify that. I think your contract is with SRA.
Correct.
The contract that Mr. King signed was with a company called SRA Capital. He did not know that on that day that the title owner was in fact Mr. and Mrs. DeLay. And so what Partridge did was he got a deed from the Delays and then into SRA, and then Partridge actually flipped it into Mr. King and recorded, or his wife's title company recorded those deeds together. I mean, Mr. King didn't even realize that SRA at the time wasn't the title owner of the property.
Okay. Was there a closing statement at that?
I only got to see my half of the closing statement.
Isn't that unusual?
Well, the way it was put, Mr. Partridge found out afterwards is a discharged attorney in the Commonwealth of Virginia and had represented the legal aspect of that at the time.
Is it true that one capitalization fee has in fact been paid?
Yeah.
And that was paid by whom?
Mr. Partridge paid that on my behalf. He also paid 2 months of the monthly dues in advance as well, which was promptly refunded to him and then ultimately credited back to my account.
You say he made this payment on your behalf. I would look at it as though he made it on his behalf, because he was the purchaser of the property.
For 30 minutes.
For 30 minutes, yes. Did you reimburse Mr. Partridge for this capitalization fee?
No.
So he has made a payment to us of $2,000 because he purchased property. You have not paid him for that. You are buying property from him now, but don't feel that you should pay capitalization fee.
He was managing that property on my behalf, which turned out not to be the case either.
So in your closing statement, you did not show you paying the $2,000. Partridge doesn't sound like the kind of gentleman that would, out of the goodness of his heart, pay a closing fee, a capitalization fee, and then not pass it on.
He was managing all aspects of the property as part of the agreement I had with SRA Capital.
I guess that was one of the somewhat surprising facts when we went back and looked at it and realized that he actually did pay that fee once, given other things we've learned which aren't relevant here. But this gentleman was taken advantage of, clearly in that transaction, you know. And so I just think that for him to have to pay another $2,000 would be continuing that.
But he hasn't paid one yet.
Oh, he paid much more than that in the long run. I mean, the property's been sold at nearly $100,000 loss.
That may be a different subject, but okay.
Does your settlement sheet show that the $2,000 capitalization fee was on there for Lake Holiday?
I just saw one half of the settlement sheet, and that was, I honestly don't know if it was on there or not at this point.
And you don't have a copy of that with you?
I don't have a copy with me now.
Because there's a possibility that it was paid at settlement, isn't it?
He paid it at settlement.
Your settlement sheet, through your settlement, no.
There was only one
We only got to see
settlement,
one half of the settlement
and,
sheet.
and you never got to see anything between the delays and the...
No.
But you did see your own settlement sheet.
And their title company
Well,
handled that as well?
First of all, let me just state this. When the appraisal was done on the property, and this is part of the big picture, the appraisal was done before any paperwork was signed. I found that out after the fact. The appraisal also stated there was no homeowners association. Had I have known there was a homeowners association, I would have requested copies of the documents immediately. I understand the 72 hours that I have to review and make a decision and or walk away. Had I have known that, I would not have gotten involved at all. I would have walked. So I was not given the benefit of anything, and when I asked Mr. Partridge, his comments on a few occasions were, I was an attorney, I do not want to wear an orange jumpsuit, I will not steer you wrong. So with that said, I was had by him, I was had by his association in getting the appraisal done through the bank, and clearly on that it stated absolutely no homeowners association, because I also live in a homeowners association where I'm part of a board as well. So I understand that those rules do apply and certain things have to go through. So I was never aware of it, and I honestly don't know, and I do not believe it was on the closing statement sheet. Because he was taking, as part of the contract that he had put in front of me, that was reviewed, was he would take full management responsibility, get someone in the house and sell it as well, which nothing ever materialized.
Steve?
I'm just gonna say how I feel. The man was taken advantage of. I don't want to be a part of the continuation of that, regardless of what the letter of the rules say. This is part of the kinder, gentler community that I've been talking about for a couple of years, and I would suggest we waive the capitalization fee for him. I'll make that a motion if necessary.
I agree with Steve. I think in terms of fairness, and this is a very extraordinary thing to have this, that we describe it, I think we got to waive it as well.
I support that.
This one.